First of all, thank you all very much indeed for coming along, so numerous, so avid, so expectant, hoping to learn, I hope, lots that you may not already know about arbitration. A show of hands first, if I may. How many are actual arbitrators in the room? Right. So that means that the majority are not, which is very much a very good thing. We hope that by the time you leave, you will have carried the interest that brought you here through to a satisfactory denouement, and that you'll go away and think in relation to all your current cases, are these clients who would benefit or might potentially benefit from arbitration. It's going to be quite a busy and jam-packed evening, and you certainly don't want to hear, although I'm afraid you're going to have to hear first and last from me. I'll keep it very short. I can certainly keep it short in relation to our first surprise speaker. We're delighted to have Sir James Munby here this evening, our president. He needs absolutely no introduction, and is certainly not going to get one from me, nor would I dream of giving him guidance. James.
Thank you very much. I'm conscious that if I go on for more than 2 minutes, I'll be eating into Nicholas Mostyn's time.
Go on.
And that would not be good for my physical or mental health. So I'll try and keep it short. That is short judged by your standards, not by my standards. Can I just say that I'm an avid enthusiast of all forms of what we must no longer call ADR. I think the current jargon is NCDR, non-court dispute resolution. My own view is that it is unfortunate, in a sense, that the government decided that the M word was the only form of ACDR. Mediation is very, very important, but mediation is not necessarily the right tool to use in a particular case. And one thing which is very clear to me is that different methods of ACDR each have their validity, and some are applicable and appropriate in one case, not in another, and the other way around. As you are probably all aware, I am an avid supporter of arbitration in family cases. Please note the significance of my carefully chosen phrase, family cases. I'm not confining my remarks to financial remedy cases, and as some of the more learned of you will know, I gave a judgment, was it in January this year, January last year? January last year, which in effect endorsed the IFLA and comparable arbitration schemes in relation to financial cases. I'm glad that the use of arbitration in family financial cases has been as large as it has, but would obviously like it to be even more so. I'm not going to steal Nicholas's thunder, but as one of our brethren pointed out recently, if you don't like the presidential diktat that you must use only one bundle, and you want to use 1,000 bundles in your financial remedy case, then arbitration is your solution. If you do not want to run the risk of appearing in front of YJ, where you may find yourself in open court if you want complete confidentiality, then arbitration is your solution. I'm only here today to do two things. One is to announce, and here it is, about half an hour ago I published guidance in relation to arbitration in the family court. It is now publicly available. It follows very closely the recommendation, indeed the drafting of Nicholas Mostyn's working party some time ago. It is merely guidance. It doesn't change the law. Mr. David Burrows, Solicitor Advocate, please note, it does not purport to change the law. It merely offers guidance as to how to use the existing law in practice. It explains in particular if you need to engage in an arbitration claim. And if you don't know what an arbitration claim is, do not worry, because the guidance explains it. It explains how to navigate yourself into and as quickly as possible out of the commercial court before you come back to your happy resting place in the family court.
Division.
Family division. My apologies. It is only interim guidance in this sense. I very much hope that the existing jurisdictional barriers which necessitate recourse to the commercial court will disappear in the not-too-distant future. That depends upon legislation. I'm also very keen to hear the recommendations of what I understand is the IFLA Working Party, which is busy producing plans for arbitration in children cases. And that, I think, is an interesting and exciting development. It is not, of course, a complete novelty, since, as some of you will recall, Mr. Justice Baker gave his benediction to such a process a couple of years ago. Anyway, I'm really here to do two things, one of which is, so I'm told by Peter, to add yet more lustre to the proceedings by being present in my own person. I've done that. Secondly, to announce... You laugh, but it's an important part of the President to be seen. Secondly, to announce, as I've done that, the issuance of the guidance. It'll be there tomorrow if anybody who wants to read it to see it. And without more ado, and apologies, Nicholas, I've eaten 2 minutes into your time. I have nothing more to say, and we'll hand you over to...
No. Back to the chair.
Doesn't say that here.
No one could be lustre. No one's lustre could be greater than the President's, and we really are extremely grateful to you for coming and for giving arbitration, family arbitration, I hope both money and children in the not too distant future, the great boost that you started with S&S back in January 2014, that you've now followed through with this guidance, which clearly shows that the courts, the judges, our judges, are in favour of arbitration and keen to see it prosper. So thank you very much indeed. The President may have to leave before the end of the proceedings, but I know that as and when opportunity may offer, which may not be very often, if any of you want to ask him questions as we mill around, then by all means do. And so, without more ado, as they say, Sir Nicholas Mostyn.
Almost exactly a year ago, I gave a lecture, if that's the right word, about arbitration, and some of you may have been there. So, for those of you who have been there, my slides will be familiar. It shouldn't feel too bad. It'll be like booking for the old production, the revival of the old production at Tannhäuser, which is coming on next year. It will be quite similar. And the reason it's similar, and I make no apologies for that, is because I don't know very much about arbitration. I am the hoplite. You are the Olympians. I should be listening to you rather than the other way around. And what my slides do is ask a number of questions. So I hope that you will feel free, as we go through them, to supply the answers to the questions, because when I recommend arbitration, as I do from time to time from the bench, I would like to know what I'm recommending. And I would like to have some of the questions that I'm going to pose to you answered. So, let us begin. Pros, as it seems to me. Hello, again. There we are. Confidentiality. The President has already referred to the merit of confidentiality, and it needs no more explication. And of course, you choose, as the President has already indicated, you can choose by mutual agreement the identity of your arbitrator, and you can choose, and you have flexibility of choice as to the shape of the proceedings. Is it going to be traditional adversarial? Is it going to be more inquisitorial? Will it be entirely virtual? Will it be only on paper? You have the choice, by mutual agreement, to select that. You have, as the President has already indicated, freedom to part from the bundles diktat. Although, interestingly, I asked the question, here's my first question, whose call is that? Is it yours, or is it the arbitrator's? And you can agree multi-bundle trench warfare, as has already been highlighted by the President. But perhaps there is a future pro. Fixed pricing for each stage of the proceedings. From the first stage, Form A to the first appointment, the second stage, from the first appointment to the FDR, and for the third stage, from FDR to trial. Now, I really strongly believe, although some solicitors would dispute, that the most demoralizing aspect of being involved in traditional matrimonial litigation is your sense of being completely disempowered when it comes to costs. And if there was fixed pricing, or at least a cap on pricing, which could be agreed in arbitration proceedings, then you would give considerable peace and comfort to a lot of disquieted litigants. Of this I have no doubt at all, having seen the distress and disquiet and discomfort experienced by litigants in the proceedings that are conducted before me. Lord Neuberger, as I cited in J&J, said, hourly billing at best leads to inefficient practices, at worst it rewards and incentivizes inefficiency. It undermines effective competition in the provision of legal services. It penalizes well-run legal business whose systems and processes enable it to conclude matters rapidly. It penalizes the able, those with greater professional knowledge and skill, as they will tend to work at a more efficient rate. In other words, hourly billing fails to reward the diligent, the efficient, and the able. Its focus on the cost of time, a truly movable feast, simply does not reflect the value of the work. And I myself said, the merit of arbitration in a proceeding such as this would, in my opinion, take off if that service offered fixed pricing as a standard feature. And I regard this as a very substantial future pro. And I know Toby Hale has written a good article in the Law Society's Gazette, or possibly Resolutions magazine, in which he has said that his firm has rolled out fixed pricing arbitration, and I believe there would be a substantial take-up. But I may be deluded and overambitious. So there you have the barrister. Costs should never be capped. And there you have the judge. Of course, costs should be capped. Now, obviously, it is fundamental that a family arbitration is conducted under English law. And it will never be supported by government if there is even the tiniest crack in the door marked religious door. Now, I assume that this is only a reference to substantive English law, because I assume that the parties can agree to modify procedural law. Or can they? Can they agree to say, we will conduct an arbitration without disclosure?
Yeah. Yes. Yeah.
Can they agree to say we will conduct an arbitration without for me?
Yes.
Well, there you go. And whose call is that? Does that have to be agreed by the arbitrator, or can the parties agree between themselves and impose it on the arbitrator?
Following his appointment, it has to be approved by the arbitrator.
Well, I'm learning something. You see?
But they can agree amongst themselves before they get to the arbitrator, and he is then bound to follow it or not accept the arbitration.
Is that right?
Yeah.
Well, I didn't know that either. So these are very substantial advantages, because the problem with procedural law is it is, of course, one size fits all. And even though that there are slight fast tracks for very small cases like variations, but generally it's one size fits all. And indeed, the report of our group has suggested that inasmuch as there's been a proliferation of Forms E, that should be abolished and we should standardise and have one Form E. So the movement in the traditional sphere is for complete standardisation of procedure, and with very little opportunity for departure from it. And this, I suggest, is a very substantial advantage. So I now turn to some questions. I put them as cons, but they're really questions, okay? And they are these. Question of take-up, question of increased costs, question of third parties, question of the development of the law, and the question of appeal rights. And I want to discuss all these 5 things with you. So take-up is obviously the most significant question. So I ask you this question: for which sector of the litigating community will arbitration actually appeal? I mean, I said here, it's like Goldilocks' porridge. The parties are not so hot as to be foaming for full-blooded court warfare, yet not so cool as to compromise by mediation. I was watching the first episode of the 2nd season of The Affair, excellent programme, last night, and the mother-in-law says to her divorcing daughter, when are you going to give up this humanitarian project called mediation and go to litigation? And so they're not going to go for arbitration. So I ask you this question: if people are sufficiently engaged with the humanitarian project to be able to agree arbitration, why are they not resolving their issues by Mediation. The answer, I suppose, might be that there are some issues that can't be mediated, although I do recall in Al-Khatib versus Masri, Lord Justice Thorpe saying there is no issue which is not capable of a resolution by mediation. And I'll come back to another comment from the mediator.
The identity of the petitioner's counsel.
The identity of the petitioner's counsel. So, but it's a serious question. We know, I suggest, is it going to be a very small sector? Because we know from the lecture that was given this time last year by Sir Bernard Eder that in most commercial arbitrations the parties have no choice because it's written into the contract. And the election to do what they call ad hoc arbitration is very, very small indeed. Where you don't have to arbitrate in the commercial field, people tend to litigate. So the question I ask is, who is actually going to take this up? Now, is it a question of selling it to the public?
Selling to professionals.
Is it a question of selling it to the professionals, in that there is something more advantageous? So it's not so much a con, it's a question of, is there in fact a community out there for whom this will appeal? I would mention, in a heavy case, the cost of the arbitrator will be significant, which is obviously a disadvantage compared to the court, where I come almost free. And the cost of the room hire will be significant. Again, that is basically provided almost free, but I don't regard that as very significant. Third parties, I don't know if you agree with me that it is doubtful that in an arbitration an order could be made joining a non-consenting third party, such as a company,
Correct.
for the purposes of a binding declaration as to the ownership of property. Query whether a variation of nuptial settlement could be made in arbitration proceedings where the trust does not agree to be bound. Do we all agree that that would be a problematic scenario, which is quite a common scenario, it has to be said, in terms of the bigger cases that we do, because it's not uncommon, of course, for richer people to have their assets held in corporate or trust structures. I mean, that is a very, very common scenario. And then there is, of course, the development of the law. Now, we know that there are a number of statutory reforms on the horizon. I'm told that Baroness Deitch's bill has resurrected after the election, redrafted by none other than Lord Walker, apparently, and she is moving to have it reintroduced. Will that change the law? We know that the Lord Marx's bill on cohabitation proposals, he's going to have another crack at that. Whether that will get anywhere, one doesn't know, but with the House of Lords, one can't be so sure. Every reform, as Joseph Jackson used to say, what did he used to say?
10 years work for lawyers.
10 years' work. And every reform requires protracted working out by the judiciary. And I suggest or state that arbitration can only realistically flourish if the law is stable and settled. If the law is not stable and settled, then one wonders if arbitration is an appropriate route for people to adopt. But it's only a question. I'm not. So that's another aspect which I would invite some comments from the floor about. These aren't, I perhaps have overstated them as cons. Appeal rights. Now, under the Arbitration Act, you can only appeal an award on a point of law or for serious irregularity or for want of jurisdiction. Is that agreed?
Yeah.
So I ask this question. Is a plainly erroneous factual finding or a gross misexercise of discretion an error of law or a serious irregularity? But then I ask this. Do you need any appeal rights if every award in our field must be made the subject of a mirror order by the court? That's an interesting question and takes us on to the President's decision in S&S. What test will the court apply if one party seeks to resolve from the award when the mirror order procedure is adopted? And what the President said at paragraph 21, the test is, something has gone so seriously wrong in the arbitral process as fundamentally to vitiate the arbitral award. And then he said in paragraph 26, in most such cases, the focus is likely to be on whether the party seeking to resile is able to make good one of the limited grounds of challenge or appeal permitted by the Act. And so, this is me, in my opinion, for what it's worth, a plainly erroneous factual finding or a gross misexercise of discretion is a sufficiently serious error in the arbitral process as to vitiate the arbitral award fundamentally. And in my opinion, this would justify a refusal to endorse the award and to direct a retrial before the court. And I do recognise that this sets us apart a bit from the commercial world. So this takes us to the excitement of today, and this is a pregnant elephant. Now, you will see elephants are pregnant for approximately 640 days. Now, why am I showing you a picture of a pregnant elephant here? Answer? James.
You're determined to progress your career by insulting the person.
The guidance has taken a long time coming. Not quite as long as an elephant's gestation, but nearing it. But we're grateful for the arrival of Baba nonetheless. So here we go. The guidance is divided into 6 parts, a preliminary section, and then 6 parts lettered A to F. The preliminary part confirms, as the President has just said, that the guidance is not just confined to ancillary relief. It confirms that the guidance is equally applicable to Talata claims and claims under the Inheritance Act, although the guidance does confine itself to only financial proceedings because child arbitration is a work in progress, as we know. The first substantive part deals with the situation where there are subsisting proceedings. Okay, well, there are 5 sections. Subsisting proceedings seeking the same relief as in the issue in the arbitration. Arbitration claims, arbitrations conducted where there's no subsisting proceedings, enforcement, challenging the award, and then F is my favourite bit, the standard court orders. So under A, the first deals with the stay of proceedings, and then there are 2 situations: applying for an order to reflect the award where that's by consent, and applying for an award to reflect the award when it is not. Now, section B deals with arbitration claims, and these are claims to determine, they're going to be very rare, whether there is a valid arbitration agreement or whether the arbitration tribunal is properly constituted. Now, these are going to be very rare, although they're very common in the commercial field. If there is a dispute, and funnily enough, I have got one rattling around a bit, where there is a dispute about whether the parties have reached an agreement about to arbitrate, then the claim must be issued in the commercial court, but the application must ask prominently for transfer to the family division, not the family court, because it can only be done in the High Court. And can you confirm that the judge in charge has confirmed that that will happen? Mr. Justice Flo has said it will happen.
He has seen the guidance and is content.
He has seen the guidance and is content. So it will be issued in the commercial court and then will be whizzed straight over. But these are going to be very rare, in my opinion.
Except that applications for enforcement of peremptory orders or for the attendance of a witness under sections 42 and 43 of the Arbitration Act are also arbitration claims.
Oh, okay.
And so those are the ones that may well happen.
Well, that comes in section E of this. But I see the procedure will be you may have to go via Mr. Justice Flo. Section C is where there are no subsisting proceedings seeking relevant relief. The first part of the guidance deals with the stay of the proceedings, but the second part is interesting. It refers to the case of JP and NP, which follows the decision of McCartney, which says that under the rules, 29.15, a court may hear and determine a financial remedy claim before decree nisi and direct it takes effect on decree nisi, but subject to decree absolute. Now, this will be an important, useful procedural tool if you are applying for an order to reflect the award and you haven't yet actually got round to sorting out the divorce. You'll apply for the court asking it to make the mirror order, but to take effect on decree nisi. And then in the same terms as section A, it deals with guidance about what should happen when the mirror order is opposed. There is then a section on enforcement, and that is section 66. The guidance explains allows the award with the court's permission to enforce in the county court in the same way as a judgment or order of the court to the same effect. The guidance explains that's okay for Talata awards, but it's not for ancillary relief awards because of the requirement of a mirror order. And then there is section E, which is the guidance deals with when you want to challenge the award under section 67 to 71 of the Act. It's so unlikely to arise, and I haven't got time to deal with that. And then the wonderful part, which are the standard orders, which follow the template, exactly as one would want. There are 3 particular orders there: the stay pursuant, the stay order, enforcement of an arbitrator's peremptory order, an order securing the attendance of witnesses, and then there are some revised recitals to be inserted in place of the existing ones where in the omnibus, either the main omnibus or the children omnibus. Now, I have heard, the President has referred, and I know it's on your agenda, that you're soon going to be moving to child arbitration.
Right, good afternoon, everybody. For those of you who don't know us, I'm Gavin Smith from One Hair Court.
I'm Andrzej Bajowski, Bedford Road. And I'm Duncan Brooks from QEB.
Good choreographing, guys. In this slot, based on our own arbitration experience, we're going to try and do three things. One is to dispel some misapprehensions about family arbitration. Secondly, we're going to try and clarify some aspects of the process that may be unclear. But most importantly, we're going to try and persuade any waverers that arbitration is a jolly good thing. Now, not to be outdone by some people called Gavin and Stacey who are coming next, we're having our own mini chat show, so please don't hesitate to chip in at any point with questions, or if you prefer, leave them to the end. So, first of all, to the first topic, which is that there is a perception among some practitioners that arbitration is only for big money cases. And I'm going to ask Duncan to give us the benefit of his views.
I would entirely disagree with that sentiment. I have had the benefit of doing 2 as a barrister, 5 as an arbitrator thus far, and I think only one of them could be classed within the big money sphere. The rest certainly weren't. The reason why I think it's very good for smaller money cases, well, there are different reasons really, but the first I would say is if you aren't at the stage where you need to issue an application, so you've had voluntary disclosure, as we're encouraged to do, you can't reach an agreement, and it's a case about a house, a mortgage, a car, some debt. Why go to court, issue a Form A, when if you can't agree it, and you've tried as hard as you can send it off for one quite short hearing where someone can make the decision for you. Now, that's not to say you can't settle it in the meantime. However, it does seem to me that that is, and has proved to be, a very effective way of dealing with disputes without having to start again with new Forms E, wait for a first appointment, then a court FDR. If you want an FDR in the meantime, you can arrange a private one, you can have a roundtable meeting, but quite regularly, these type of cases are the ones that can benefit from being outside of the court system rather than inside of it.
Thanks, Duncan. Andre?
Really, very, very little to add to Duncan, what Duncan said. My experience likewise has been mainly the cases are lower value. And because you can deal with them so quickly, you save a great deal of time and expense for the people who are involved. And those are the cases where, generally speaking, they're not being awkward or difficult or particularly opposed to each other. There's a genuine difference of view, and they can't find any common ground just by mediation or anything else. And arbitration is a very neat way of bringing a conclusion very speedily for them.
I agree. I think arbitration is suited to all sizes of case, in particular small money cases, which can be dealt with on paper. Parties often can't afford the cost of going to a final hearing. My own arbitrations have ranged from 300,000 to 2.6 million, with a sort of a cluster in the middle of 1.1 to 1.8 million, so I don't consider those to be big money cases. But I think it's also wrong to look just at asset value, because there are other ways in which arbitration can help people, and that is to deal with discrete issues, such as whether a particular property should be sold or transferred, or whether there should be a term on a periodical payments order with or without a Section 28(1)A direction, to deal with chattels, or when people are dipping in and out of the court system, you can have a first appointment dealt with by an arbitrator, you can have an MPS hearing dealt with by an arbitrator, or a directions hearing dealt with by an arbitrator, and then the case goes back to court. So let's move on to topic number 2. Andre, some practitioners are said to be reluctant to use arbitration for fear of being criticised by their client for recommending a particular arbitrator if he or she then goes on to deliver an award that the client doesn't like. What do you say about that?
Well, it's true. It's probably the excuse I've heard people express most often when I've asked them why they're not arbitrating, because you come to these events, people are very interested in the arbitration concept, they understand the benefits of it, and then they use that as an explanation. And I wonder to what extent it's actually an illusory problem that they fear more than is actually a real concern. Lawyers, all of us, are often giving really important guidance to clients. Solicitors are advising them which barrister to use. You advise them on which expert to use. You advise them on all sorts of aspects of the case that are very much determinative of what's going to happen. So why is this significantly different to that?
And I've certainly not heard, I don't know if any of you have heard anything anecdotally from any of the cases that have been through arbitration, of anybody having anything other than very positive things to say about the experience they've had from an arbitrator compared to the experience that they know they might have had they been in court. But if it is still a concern, I think there are ways around it. In fact, Gavin wrote quite a good article for the Family Arbitrator website about a year or so ago, suggesting various options. Clearly, with your own client, you can give them a list of 5 or 6 different names that you would recommend, give them the profiles and see if they will select one from that list. More often, the problem you're going to have is getting both sides to agree on the common arbitrator. And again, there are ideas around dealing with that. You can get both parties to submit a list ranked in order of preference. If there's a common name on both those lists, that's the name that goes forward. If there are 2 common names, the one that's most highly ranked might go forward. You might decide to simply have a list of 5 names ordered in priority, take turns rejecting the one you don't want until one name remains. You can go to IFLA and ask IFLA to just nominate somebody. The scope is there within the scheme, as I understand it, to do that. But that, of course, takes away one of the big benefits of arbitration, which is selecting somebody who's got the right experience and skills for the case you've particularly got. You can even, and I've not heard of this happening anywhere yet, but you can even appoint an arbitrator to identify the arbitrator, which is an interesting idea, but why not?
Well, civil.
Yeah.
They have one each and they've agreed.
Duncan?
I think all I'd add is what you're paying the arbitrator to do is listen to you, be polite, make a decision that is sensible, reasoned, and what you'll find invariably is they'll have read in, they will deal with what a court would deal with in less time. Yes, it may well be that you are paying for someone who makes a decision that you or your client aren't particularly happy with, but is that different to going to court? Because really what you're saying is, I'd rather have the roulette wheel of a different judge coming across with a different decision from the way I'd hope it would go. So ultimately, I think as long as you can find someone who you trust to make a sensible decision, it might be it doesn't go entirely your way, but how many cases can you predict will as lawyers?
I agree. Solicitors and barristers are well used to advising their clients in a number of different areas, including, in the case of solicitors, the instruction of a barrister, and in the case of both of them, the instruction of a single joint expert. And Andre has identified a number of ways in which the responsibility for appointing the arbitrator can be spread between the parties. And of course, if all else fails, there is one other tried and tested method, which is both swift, it's cheap, and it's transparent, and it works like this.
Heads.
Tails. Duncan, you're hired. Duncan, are there cases which, in your view, are not in principle suitable for arbitration?
I think you might face a negligence suit if in a case where you've got an English wife and a French husband and both would have jurisdiction, you send the first letter saying, how about we arbitrate before we issue divorce proceedings, and the other side jump in and seize jurisdiction elsewhere. So, yes, clearly you're going to want to be careful in an international context. Secondly, as you've heard from Sir Nicholas, you can't force third parties to engage in arbitration. Therefore, there might be difficulties if you have third-party interests, trustees. And I think the third category I can think of is if you are going to need to keep going back to court for peremptory disclosure orders, then rather than going to an arbitrator to then go to court to get the disclosure from third parties, you might be better off staying in court. But really, although that might occupy a lot of the High Court time, most cases at family court level and the lower tiers don't have those issues running in the majority of cases.
Thank you.
I agree, I can't think of any others.
I would only add, I think if there are allegations of very serious non-disclosure, those sorts of cases might be more appropriate for court than for arbitration. And I think also where there are doubts about the other side's commitment to the arbitration, if you think it's purely tactical, it's a delaying tactic, then again you might not want to go down the arbitration route. So, let's look now at the benefits of arbitration compared with litigation based on our own experiences. Andre, let's kick off with you.
For me, I'd stress the flexibility, and if I give you three examples from cases I've done just to show you the differences to the normal process that people would have followed. The first one, quite a low value claim, actually dealt with as an all issues financial arbitration. Parties had been to mediation, failed to get anywhere. And before they'd even issued proceedings, the solicitors decided to go to arbitration. For this reason, they'd sold the property. There was a modest amount of equity that had been released, which was sitting on account in a solicitor's account, while both parties were in rented accommodation. They wanted to move on. There was one issue that they were clearly not going to resolve, and they'd agreed to disagree about it. They took that to arbitration. Had they gone to court, going all the way to the final hearing, even if they'd used the first directions hearing as an FDR, would have taken at least 6 months, probably 9 months. They dealt with it having signed the ARB1 in July, in the middle of September. And the only reason it took till September is because we had August in between and nobody could find a date in the holiday season. So that was a case which had the benefit of speed by bringing the process shorter. The second one I did was a couple who were expats living in Dubai. They had again been to mediation in Dubai, had reached an impasse. They were referred to me. I very quickly identified on the face of what they'd sent me that there didn't appear to be any dispute of fact. It was just a simple case of exercising discretion on a couple of discrete points. We all agreed that we'd do it on paper. They sent me their submissions, each acting in person, though clearly there were lawyers in the background who had assisted them with it. And I then wrote my award on paper. The whole process was dealt with at a fee of about £1,500 because it was only about 3 hours of my work at the end of the day. Avoided a trip to London for at least one, probably 2 hearings. Avoided all of the expense that I would have dealt with. Third one, very quickly, totally different sort of case, Talata. Trusts of land case which would have otherwise been dealt with in the civil courts. Family lawyers on both sides who are obviously a little bit concerned about the post-Mitchell and Denton environment, which is quite punishing and punitive if you fail to stick to time limits and directions. And a good example of how arbitration worked very well for them was that we fixed the date in July. Turns out there'd been slippage in the timetable. They weren't ready to go. They'd agreed to adjourn. They approached me to see if we could adjourn the hearing. We did, to a date 3 weeks afterwards. More slippage, they still weren't ready. End of July, we went to the beginning of September. There was a problem with that date. We then got another date, end of September. Had they adjourned that first hearing in the county court, well, first of all, the judge may not have agreed to adjourn it anyway, but had he done so, when would the date have been? A long way later than September. So it's that flexibility which you have in this process, which you simply can't get in the court system.
Thank you, Andre. Duncan.
I think I probably headline 3 things. One is cost, because the initial reaction is always you're paying for a third person in the process to decide for you. But I think you actually make up that cost and some, because of all, you save the litigation delays. You will get hearings, as we know, quicker than you will generally get from the court. Secondly, most will do fixed fees or a pretty low value anyway. But with that, you will have, invariably, people having read in, and so you are starting on day one at 9 or 10 o'clock, whenever you agree, with someone who is on top of the issues between the parties. And secondly, they will give you a full written award. So examples I can think of, my first arbitration was as a barrister. It was a 3-day trial, but we managed to deal with the hearing in a day. So we saved 2 days of refreshers, 2 days of solicitors' attendance behind us. Same as an arbitrator, I've yet to have a case where the hearing element has gone beyond a day because I've pre-read and they get a written award, usually within a week or so. It's less intimidating for the parties. So when they are giving evidence, although they generally do so on oath, they don't have to, but also they're not in a court setting. It's usually around a table. You can set it up how you like. And I think people find that much less intimidating than the court process. And more than half of the ones I've been involved in, the parties have chosen to be referred to by their first names. And I think that was out of comfort zone for most of us when we first started. But actually it makes very little difference and you can get round it. Flexibility, I think the example I can think of was, 2. One is it was a children dispute with child maintenance, that was it. Variation of it. So there was an agreed schedule. That was all the disclosure the parties wanted. And it was submissions, no oral evidence, and it was dealt with in half a day. The other example is where I had a relatively standard case where the main issue was how much do people need to buy a house. That was going to inform what they needed by way of income. And rather than dealing with everything in the round, we agreed that housing would go first, and we had both parties giving evidence effectively simultaneously on the issue of houses. So rather than one person in the witness box telling you about the houses, then the other person goes in, we had them both there, and I could say, well, what do you say about this? What do you say about that? And it meant it was much easier for me to drive what I was interested in as the decision maker, but also get quick feedback without it waiting for that passage of evidence to finish and the next witness to step into the box.
Duncan, thank you very much. I agree with what both Andre and Duncan have said about flexibility, and I'll come back to that in a moment. But for me, I think probably the most important thing is to be able to choose the arbitrator and to have continuity of arbitrator throughout the entire process, and for that arbitrator to be available to the parties and their solicitors to deal with directions, to deal with issues that may arise. And I always make it clear at the very outset, look, I'm here, you can just email me, jointly of course, or we can set up a conference call to deal with issues. And I think they find, the clients and solicitors find that immensely helpful. The other thing is the lack of pressure during the hearing, if there is a hearing. You haven't got a frazzled usher or harassed judge putting pressure on you all the time to come into court or to let you know what's happening. The arbitrator can just sit back, let them negotiate if they want to negotiate, let them start late if they want to start late. After all, they're paying you. And I think also the requirement that the judgment be delivered by way of a written award is very important, because that gives the arbitrator, the judge, time to reflect, time to draft a clearly, carefully reasoned written award. In terms of flexibility, there are clearly a number of issues here. One is procedural flexibility, whether it be on paper or whether it be determined by way of a hearing. 2 of mine have been on papers only. The other 3 have involved hearings. The clients and solicitors, their default position is, can we do this on paper? And obviously, if you want to help them, you want to provide a service to them, and so if you can, you'll deal with it on paper. But what I generally do is I defer that, unless it's completely clear-cut. I defer that until a later stage in the proceedings when all the evidence is in, and then we take a decision as to whether it can be determined on paper or not. Again, evidential flexibility, you don't need a Form E necessarily. In a couple of ones I've done, there's just been an agreed schedule of assets and a Section 25 narrative statement. That's all you need. Flexibility in terms of the stage at which the arbitration comes to you. There may be no Form A, they may have tried mediation or a private FDR, or at the other extreme, the parties may have travelled a long way down the litigation route. One example being, I was rung up by counsel after a failed FDR saying, can you fit our 3-day final hearing into your diary? And we did. Or as I said before, that the parties may be dipping in and out of the court process. And finally, the other element of flexibility is, of course, single issue or full range of financial claims. Speed, again, extremely important. The S&S case arbitration I did, that only took 6 weeks from the date of the ARB1 to the draft award. I had an even shorter one than that. It was a 2-day final hearing which actually settled and took under 2 weeks from the ARB1 to the date on which I provided my consent award, which was the day of the hearing. So I think we move on then to the final issue, which is, Duncan, do you have any tips for practitioners with a view to making the arbitration process as user-friendly as possible, and one that the solicitors will want to repeat in future cases?
Good coffee and good sandwiches, first of all, the most important thing. But on a more, well, that is a serious note, but more seriously, think what's needed, because the one-size-fits-all process is wonderful because you have a checklist in Form E of what you need to disclose and so on. But in many cases, you don't need to go through that. So what is it that these parties want a decision about, and what do you need to get to a decision? I think really that's the fundamental thing behind it. Do they want to be formal and treat it like a court hearing? Do they want it to be more informal and provide the disclosure that's really going to be germane to the issues in a small money case, and to keep it first names? And again, it depends on the people who are going through the process and what they want. But genuinely, I think that the experience I had, first of all, as a barrister, and the experiences I've had as an arbitrator, are that it is a preferable process where the parties can agree, because it is quicker, I think cheaper as a whole, and you have an arbitrator who wants to help you and is providing a service and doesn't have the pressure of other cases in their list vying for time. So really thinking about what you want, I think that's the main tip from me.
Okay.
Yeah, I'd echo that. I mean, I always say that as an arbitrator, I'm their servant, not their master, which is quite different to being a judge. I'm there to provide a service for them. If they want time to talk, so long as they understand that if we don't finish it in the day, there are financial implications for that, I'm not going to put them under pressure, because if they're not calling upon me to make a decision, I don't need to make a decision. I'm only there to do what they require of me. So that fits into the flexibility as well, in terms of trying to guide them through the process to some extent as well, and perhaps show them options that are off the normal piste, off the normal beaten track, that might be more efficient than what they're proposing to do. And then there's little add-ons that you can give, such as just being more accessible by way of email, dealing with rapid directions by way of exchanges of emails and reasons given from that. And at the end of it, draft the order for them. So they've got something to take away, which they can lodge at court as a consent order without there needing to be a further toing and froing over the final terms of the order.
I would only add to that a couple of things. One is the importance of holding a preliminary meeting with the clients and solicitors. This is something that Peter Singer devised. It's an excellent idea, and I adopt as a matter of course in my arbitrations. I know other arbitrators do the same. It's a two-stage process, or at least the way I operate it. The first stage is a without prejudice meeting. They come and see me. I explain to them a bit about the arbitration process. I satisfy myself that they understand the obligations that they enter into by signing the Arb 1, namely they agree to be bound by my award, they agree not to go to court save in support of the arbitration, they agree to give full and frank disclosure and to comply with the arbitrator's directions, and finally they agree to apply for a consent order if that is necessary. So the solicitors may have queries about the process. And in one, the solicitor said, will you be doing an FDR as part of the arbitration? And of course, the arbitrator can't do an FDR as part of the arbitration. So it was helpful to have that and to lay that to rest. Then, if they are happy, they sign my terms and conditions, which they've had previously, they've had time to look at and to discuss my fees. Once the terms and conditions are signed, then we proceed to the direction stage, because it is at the point that the terms and conditions are signed that the arbitration formally commences. So then we turn to directions. It may not be possible to give substantial directions, but at least I can set up maybe a telephone conference or a face-to-face hearing to consider directions. I agree entirely with Andre. Drafting the order is an excellent thing. When we think of how often it takes as barristers and solicitors to agree an order with the other side, it takes ages, it increases costs, increases acrimony. How much simpler for the arbitrator who knows what the order should contain, because it is he or who has delivered the award. How much easier it is for the arbitrator to draft the order. And finally, if the case settles during the course of the arbitration, this has happened to me twice, I've said, well, I will do a consent award for you, because that has two advantages. One is it arguably gives greater finality than a CDS agreement, and also it opens up the S&P fast-tracking procedure for converting the converting the award into a consent order. And I also hand out at the end of the process a standard note on how to convert the award into an order. So the only final thing I'd mention is practical matters. It's really helpful to have a suitable venue. Don't be tempted to use rooms in chambers or in your offices, which may not be appropriate for the hearing. Actually, hiring premises is relatively cheap, and there are some in the Temple area which are very suitable. But that is something that needs to be borne in mind, and I think that is all I have to say about tips.
One thing we haven't answered is the bundles question. So, do you have to, if you're appointed and you're asked to deal with 500 bundles and so on, do you want to deal with that?
Well, obviously we're not subject to the constraints to which we practitioners are subjected to in court. It's up to you. The arbitrator will say, well, if you want to lodge 5 bundles of bank statements and you're only going to refer to 3 of them, well, that's fine, that's a matter for you. If you want to lodge a bundle with 1,000 pages of correspondence, again, that's up to you. So there isn't that pressure. Obviously, the arbitrator may actually, in the event, consider with you whether it is appropriate to have a lot of bundles, but ultimately it's really a matter for the parties.
Well, the effective filter, you spoke about a preliminary meeting and the directions hearing. If the parties want to file 5 leverage files of papers and expect you to read them, you apply a very real filter there, which is right, 5 days of work instead of 1 day's work.
Yeah.
And they then have to bear the cost of that, and that does focus minds. So there is a filter there which is probably not available to judges in quite the same way.
And the arbitrator can say no. So if you have someone saying, I want every letter to go in, and it's after the arbitrator's been appointed, this debate happens, then the arbitrator will make a decision.
But it's quite clear the practice direction does not apply.
Yeah.
So it's up to the parties in conjunction with the arbitrator to decide. Any questions? There are templates. There are templates in the rules. There's the financial remedy template, and then there's a civil template. And the parties are free to adopt that, or either of those, or any variant on them.
But when they sign the ARB1, it implies the rules, the default rules, which are effectively the same as Part 9 of the FBR. But they can opt out of that, and the arbitrator and they can agree a totally different agenda if they wish to.
Experience of that. I'm assuming that all my awards have been made into orders, because I haven't heard to the contrary, but I don't know how quickly it's taken.
Likewise, not heard.
Same with me.
Well, it'd be much better if we didn't have to refer to the CPR and go bouncing it through the commercial court. It would certainly be better to have an equivalent process within the FBR, no doubt.
And we move on now to the mock arbitration. Now, I think everyone will have had distributed in advance the problem. We quite like to save time by not having to go through it. In fact, you don't really need to worry about the problem so much as what happens with our participants in the way in which they deal with it. Don't worry about what the right answer is. Look at what they do. And so we have our arbitrator, Nicola Shaw, from Trinity Chambers in Newcastle. We have the mother, Deborah Diamond Hayward, from Albion Chambers in Bristol. The father is played by James Roberts, the treasurer of the Family Law Bar Association of 1 King's Bench Walk. The advocate for the mother is Rhys Taylor from 30 Park Place in Cardiff and 36 Bedford Row here in London. And for the father, we have Nigel Shepherd. Are you the vice chair or the chair in waiting or the...
Both of those.
Both of those of resolution from Mills and Reeve, ubiquitously.
I'm Nicola Shaw. I'm notionally the arbitrator, and the other thing that I need to say is, because we're about 15 minutes behind schedule, we're going to shorten this, some of the issues in this, so if it's a little more ad hoc than perhaps it would have been.
Yes, but not too much.
No. Rhys Taylor, I'm advocate for Stacey.
Nigel Shepherd, I'm advocate for Gavin.
Gavin, I'm mute.
And I'm Stacey. Meant to have a Welsh accent.
So, good afternoon, everybody. My name's Nicola Shaw. I know that you know who I am. I'm the arbitrator that you have appointed to resolve your dispute for you. And can I tell you, first of all, that I have read all the papers that have been sent in to me. And it seems to me that the issues that you have, that you're going to need me to make a decision upon, are one in respect of, Stacey, whether you have any, and if so, how much, financial interest in the property that is in Gavin's sole name in London, dependent on what I might find in respect of contributions that you say that you have made. And secondly, once we've gone on to determine that, then there's another issue in terms of what financial assistance that, Gavin, you might provide in respect of a home which Stacey will be the primary carer for in bringing up your daughter. With that in mind, I know you're here with your advocates. This is the first appointment, really, and this hearing is about making sure that when you come back to see me in a few weeks' time, we've got all the information that we need, or I've got all the information that I need in front of me in order to make that decision properly, and that you've both had a good opportunity to, with the assistance of your advocates, to tell me everything that you feel that I need to know, subject to the issues that are apparent. So that's a basic introduction. So today's purposes are really, you can think of it almost as a case management or a meeting, if you like, in order that we can establish what's going to be required for the hearing that we'll have at a date that we're going to fix. And with that in mind, I'm going to hand over to your advocates, if I may, just to outline perhaps for my benefit, whether any of the issues that have been given to me this afternoon in terms of procedure have been capable of agreement, or whether how much I need to determine in respect of that.
Madam, can I assist you there? We've agreed that because notionally the burden of proof would be on Stacey in bringing this claim if it was in court,
yes,
that she'll be the first party in the position of claimant, although you'll see from the ARB 1 that I think is before you that she's in fact acting in person,
yes,
benefiting from the assistance of a barrister myself, acting on a public access basis.
Yes.
My friend, of course, has the resources of top family lawyers behind him, and he's very kindly agreed that the administration that would ordinarily take place with being involved in the position of the claimant he'll undertake, but I'll bear the burden of proof in bringing the case. In terms of issues which we've been able to agree whilst waiting to see you, we can shorten the Schedule 1 issue somewhat. I can indicate that we've agreed a lump sum which is going to be paid, and we've also agreed that Gavin doesn't have any additional mortgage capacity, and we're not asking you to deal with that this afternoon.
Can I just clarify, Mr. Taylor, with you in respect to that? When you say you've agreed a lump sum, have you agreed that that's in principle, or you've agreed the actual quantum?
We've agreed the quantum as well, so we don't need to trouble you about that at all.
Well, that's very helpful. And that is that subject to the first issue, which is the trusts of land issue?
No, that's entirely an equipping lump sum. So whether Stacey is rehoused by way of purely a Talata award,
yep,
or part Talata award and part Schedule 1, or purely Schedule 1, there is a house that is going to need to be set up,
yep,
and it's a figure has been agreed, and we don't need to trouble you with it.
Just to clarify, Madam, it's the equipping lump sum that's agreed,
that's what I wanted to clarify, really.
The extent of the property that might or might not be appropriate.
Yes, absolutely.
So that's one single issue that's been taken out of the arbitration altogether, and it's good news that you've been able to agree that as between yourselves.
Can I assist as well? You'll see that we have already attempted, the parties have attempted mediation,
yes,
and that hasn't been successful.
Yes.
There's just a different view taken about the respective strengths in the Talata case in particular.
Yeah.
But it's agreed between the parties that there isn't a big dispute about disclosure. Gavin is employed, we know what his income is, and we know what his assets are. They've been fully disclosed.
Yes.
We don't need Form Z to be filed in this case, and it's agreed that the schedule, which was agreed for the purposes of mediation, it doesn't contain any without prejudice information in it, and we propose, subject to your better view,
yeah,
to that being used in these proceedings.
No, that's very helpful, and in fact that was the view that I had on paper at least reached. So we can probably move on then to the next issue.
I wonder if it would assist, Madam, just to highlight what we think is between us, and on which we would like your determination. First of all, it is housing needs.
Yes.
Clearly, that will be the first stage will be the Talata,
yes,
claim, and it may well be that your decision on that means that there's nothing left to decide on,
yes,
the future housing claims, but the Schedule 1 may still need to deal with that, and will need particulars of properties both in Barry and in Bristol. We also need to decide on the question of Stacey's employment prospects and deal briefly with that, but I don't think there's going to be much between us on what might be needed in terms of particulars there, because that informs the decision as to which town, /city, may be appropriate for housing.
Well, if I could just briefly come in there, can I say I've had instructions from Stacey, who's vehemently against moving back to Barry,
right,
and upon that basis says that it would be wrong in these proceedings to require her to produce any particulars in Barry. It forms no part of her case, and she doesn't wish to.
All right.
She wishes to move to Bristol.
All right, so that's one issue that I need to decide in the hearing today then, in terms of what I may or may not require in order to make that decision, because that's clearly an issue of fact as between the two of you, or the two, or as between Gavin and Stacey, I should say. But But perhaps we ought to look first of all at the what I see as the first issue between these parties, which is effectively the Tolata application, which for your purposes that means that the interest that you may or may not have in respect of the property in London. And I think what we need to look at first of all, perhaps in terms of that, is what procedure we're going to look at in terms of being able to determine that application properly within the arbitration, as I said, hearing which will happen in a few weeks' time. I don't know whether you've given any thought to whether this is a case where you want a pleaded case, or whether there should be simply narrative statements, or there should be a mixture of both. And I have some preliminary views, but perhaps you could address me, if you will, on those,
Well,
and then we can move on from there.
Calm down. Yes, Madam, thank you for that. Well, Gavin would like the case to be properly pleaded. There are issues of fact here, and I think we should adopt an equivalent to the Part 7 procedure, have it properly pleaded so that we know what the case is. I know that my friend is going to be suggesting a more narrative approach perhaps to that. I fear that might encourage sloppy pleading, and I think you as the arbitrator, Madam, need to have it properly pleaded so that you can make a decision on the facts, with the legal decision that you had to be made within the factual matrix having been properly challenged.
All right, Mr. Taylor, what do you say?
Well, I'd say this is a very straightforward case. The facts before you are an email in which a representation has been made. There's clearly a fully developed kitchen where there wasn't one before, and there's an argument as to whether or not the £50,000 in the Christmas card was a gift or some other contribution towards the property. It's very straightforward, and Stacey takes the view that she'd like to keep the resolution of this dispute as cheap as possible, and doesn't see why we need to go to the expense of pleadings. What she would propose to do, mindful of the need to be particular in these kinds of cases, is to set out her case in a narrative statement, annex the relevant documents upon which she relies, and she would say that it's disproportionate to have particulars and defence and disclosure and everything that goes with that. She'd be happy to answer any further questions if any arise out of her statement, but she doesn't think it needs to be more heavy-handed than that.
All right, well, in determining that issue, obviously the parties are very aware that this award that the arbitrator will ultimately make is a binding award, and that any decision that I make has got to be based on the law of England and Wales in any event. So I don't think it's necessary to have a fully pleaded case as it would be in Part 7, which for your purposes would mean if you were going through to the county court. This isn't a county court. However, I take the view that we need something perhaps in the middle of what would have been a fully pleaded case in terms of Part 7 and the narrative statement, which I think is probably a little bit too informal. That's more evidence, and what I require from you really is how this is going to fit into the Trust of Land and Appointment of Trustees Act in 1996. So what I propose, subject to what you've got to say, is almost a bullet point setting out of pleadings, but in a much shortened form, more akin to a Part 8 details of claim, and a short, I call it a defence, but a short reply dealing with those points. Narrative statements, I think, are more to do with evidence, and we'll come on to narrative statements in a moment or two, because I know, again, that's an issue that the two of you want to look at and which I need to determine for the purposes of the arbitration. But I do think that there should be a distinction between what the party's evidence is in terms of the narrative statement and effectively a short pleaded case, bearing in mind, Mr Shepherd, that we're not in the county court, and I don't want to start getting hidebound by particulars of claim and then defences, and then we might end up then with sort of Part 18 questions and so on and so forth. So that's my view in respect of that.
We're getting the nod from both our clients, so
Good.
we don't have any representations to make about that.
All right. So moving on then, the next issue is whether we need any expert evidence. I see what both of you say in that, and it's been very helpful to me to have your positions in respect of that in writing in advance. My view is that regardless of whether there is an interest in the property or not, if an interest is established, I think it would be helpful to me to have a neutral third party indication as to what increase in value, if any, the money that was put to has led to. Because in terms, it's one thing if the money has put £100,000 on the property, and it's completely another thing if perhaps it's on more soft furnishings and decor. So I think unless you seek to dissuade me, I would like a single joint expert to look at, please, the issue between what increase in value, if any, the work that Stacey says that she's done to the property has.
If I may, Madam, the only point that I would make there is that my fully pleaded submissions on that involve the word no. To the question is, in any expert evidence is required. I'm happy to elaborate on that if that would assist.
Right. Yes, well, I was just aware that somebody had a train to catch, and maybe, but that's my preliminary view, Mr. Shepherd. If you want to address me any further, that's fine. But that was my preliminary view.
I will seek my client's agreement to not troubling you further. That's fine, isn't it? Thank you.
Yeah. All right.
Did you win that one? Yes.
Moving on. Let's move on. Let's move on to how this hearing is going to be conducted. Now, there's various ways in which an arbitration can be conducted. You've both attended today. It's possible to do it on paper. It's possible to do it having heard evidence from both of you. Again, I have some preliminary views, but I think it's important that I hear from both of your advocates in respect of this before I make a decision in respect of that.
Madam, could I address you first
Certainly.
about that? I'd respectfully say that we do need a hearing. Although the facts are quite plain and straightforward, there's the email representation, for instance, and there's also the question of the character of the £50,000. And I don't see how you can come to a view one way or the other, given that the parties disagree with the interpretation of what those things are without actually having heard them give evidence. So I know that Stacey's very much in favour of having an oral hearing.
Right, and what do you say, just before I hear from Mr. Shepherd, what would you say then in respect of the narrative statement? How do you see that fitting into the evidence? Should that be the evidence in chief? Well,
I know that Stacey has got a lot to say, and she's very anxious to tell her story.
Yes.
So she would like the opportunity, if I might ask for this, to file a statement, but to be free to say what she wants when we get to the final hearing.
All right.
Madam, dealing with the second point first, if I may, I very much believe that the statements and the narrative statements should stand as examination in chief. I fear otherwise the process will unravel fairly quickly. On the other point, Gavin was aware of the fact that oral hearings weren't always necessary in these cases, but I think in all honesty, bearing in mind the factual matrix that we're dealing with in narrative statements, I would find it difficult to persuade you that an oral hearing should not take place, and Gavin will accept that.
Yes, well, thank you. I agree that particularly where there are issues of interpretation and issues of fact in terms of what perhaps was said and understandings that may or may not have been arrived at in respect of what's a significant amount of money for these people, that an oral hearing is necessary. I am conscious, Mr. Taylor, that Stacey has plenty to say and that she will want to be properly heard. And in fact, that's one of the things I said at the outset of this short hearing today, that it's important that the parties feel that they've had a good opportunity and that I've got all the information in front of me in order to make a determination. However, the point of a narrative statement, Stacey, is that you have a chance to say in advance everything that you feel that you need to say in these proceedings, and Mr. Taylor will help you in terms of what is relevant and what are the relevant issues for me to decide the case. And therefore, what I'm intending to do is to say that the narrative statements should be relevant to the issues as I've identified them this afternoon, and shall stand as their evidence in chief, which for your purposes means that you won't get an opportunity to say in addition to what's in your statement, anything else at the hearing. Apart from anything else, you both then know what each other has got to say. And it does keep the cost and the length of the hearing down, because I agree with Mr. Shepherd that there is a danger that this case will snowball and you'll end up going into a second day. And obviously I appreciate that money is a major issue for you, and that these proceedings, this arbitration is expensive in any event. And I think it's important to keep it contained. So that's what I intend to do with that.
I was going to say that might impact on the size of the bundle if the narrative statement's going to contain everything my client points out. But
the reason, Gavin and Stacey, that you have and have paid for legal representation is that you will be guided by your lawyers as to what is relevant and what is irrelevant in terms of the arbitration proceeding. It's always difficult when a relationship breaks down. Everybody has things that they want to say, but really what we are dealing with here is very much a legal basis on whether there is an issue in this property, and you'll be guided by your lawyers as to what is appropriate to put in your statements, I'm sure.
Madam, there's just some final matters that we need to address you about. First of all, there's the question of the way in which the costs rules will work.
Yes.
You'll be very familiar, Madam, with the starting point contained within the IFLA rules is that there will be no order as to costs,
yes,
unless unless arbitration misconduct justified otherwise. I note that Article 14.4 says unless otherwise agreed by the parties.
Yes.
That will be the rule. I know that Stacey is terrified of the prospect of having to pay a costs award, and that's one of the reasons she's chosen to deal with this by way of arbitration rather than litigation,
yes,
and she does not agree to changing the costs rules.
Gavin would have preferred to have had costs following the event in view of the confidence that he has in his case, but he chose the arbitration process knowing that absent agreement, which we do not have,
yes,
we would be on the default procedure, and he went into it with his eyes open and accepts that, of course.
Well, that is the default position, Gavin, and I'm glad that you've taken that on board, because that is really the only decision I can make, given that it's within the rules, and that you've signed up to the arbitration. So so that's really a non-issue then. I think we've dealt with the fact that statements should be used as evidence in chief. Issue then is to whether there should be evidence on oath. I don't know whether either of the two of you have a particular view of that.
Bible.
You.
Stacey would be more than happy simply to give evidence. She always tells the truth and doesn't need to swear on the Bible to do so.
Gavin would prefer sworn evidence to be taken, and indeed would have thought that would be the normal procedure if there were a disagreement about it.
Well, my view is that you've entered into the arbitration process because you're not going to go to court. I will hear evidence, and it will be important that each of you tell the truth. I don't see the need for it to be given, for evidence to be given on oath. You will have filed your statements, and you will be cross-examined. But certainly, I will take oral evidence. But I don't see the need, in light of the fact that you've come to this process, for it to be either on oath or even affirmed.
Madam, I'm pleased to tell you, given the hour, that the other remaining issues between the parties we've also been able to resolve.
Well, that's very helpful. There is one.
Thank you for telling me that at the last moment.
and me. Just what there is just one issue for the point of view of formality. In order to enter into an arbitration, you must sign the ARB 1. That is what effectively
yes. I do apologise.
Puts the process onto a formal setting. I know that it was a deliberate mistake that it hasn't been signed, but obviously it's very important that you do sign it, and I'll require that please to be done before you leave today.
Thank you.
Yeah, of course, Madam. Thank you, Madam.
Note from your agenda, we have David Walden-Smith from 29 Bedford Row, who is going to talk to us about the cost of arbitration and family finance justice. David, thank you very much.
Thank you. But briefly, I'm conscious of the hour, and none of us like to talk about money. We're terribly embarrassed by it, so I will get to the point as quickly as I can. I'm conscious, as I think many of us are, that the uncertain nature of the cost of the arbitral process is something that may well, understandably, put clients off. It's a hard sell if each party already has his and her expensive team of lawyers, for each of them to go with the great idea, how about let's bring in another potentially expensive lawyer? And with that in mind, I embarked on a process which got me nowhere, which was to try to create some form of matrix whereby one could have a formulaic way of determining the fees for a particular arbitration, bearing in mind the likely length of it, the value, and possibly with certain of the type of issues affecting the fixed fee that would be created by such a process. And I promulgated that amongst some of the people who've already spoken to you, and they came back. They were all very charming, but collectively it was one huge raspberry. And I think they were right on reflection. It simply won't work to have a scheme that applies to everyone, all arbitrators and all arbitrations, because it is too complicated and too difficult, plus the fact there are other problems that we're all individuals and arguably one would be creating something of a cartel. Plus, of course, within the body of people who are arbitrators, there is a range of fees. There are market values that alter between the arbitrators depending upon their experience, seniority, etc. So a formulaic system of identifying a fixed fee for any particular case won't work. What will, certainly in my experience and all of those arbitrators whom I know and speak to, is that they will provide a fixed fee. That may have certain caveats, certain potential bolt-ons. For instance, someone would quote a fee assuming the case was to conclude within 1 day of a hearing. So there'd be effectively a brief fee or the equivalent thereof, and then an additional fee were the case to go on. It may be that the fixed fee would depend upon whether there were any, and if so, how many oral, face-to-face, pre-hearing directions type meetings. It may depend upon the number of bundles. Some arbitrators I know quote an extra fee for each bundle. So the arbitration would be the one occasion you could turn up with a trolley load of bundles and find that you met your tribunal with a big smile on his face. In order to identify and to get that fixed fee, which, as I say, I think most people are prepared to give, I think the best practical way of doing it is to send a brief email rather than telephoning, and I have my clerk speak to me and say someone has phoned and said, how much would you charge for this? That's very difficult. The better way, I suggest, most of these you'll understand are personal comments rather than anything that comes from IFLA. If you send a brief note that is anodyne, that identifies the likely issues, indicates how long the case is likely to last, of course something about the scope of it, you then have a record of what has been sent to that potential arbitrator. You avoid the risk of it being said later on that you contacted the arbitrator before he'd been appointed and said, I've got a lovely lady client who's been having 20 years of misery with this man who is a non-disclosure. How much will you charge in order to get a decent award out of him? So a neutral document indicating the scope of the case. And the advantage of doing it that way is that you can send it to more than one arbitrator, so that you could have a number of quotations, which may be of advantage for two reasons. Firstly, if cost is very important and it is price sensitive. But the other is so that you could have a number of arbitrators who've given quotations that are within a band that is acceptable. And then to deal with one of the points that was raised earlier in terms of the identification of the arbitrator and the potential risk that if you have a result that's adverse to your client, you get the blame, is that you can send your ARB1 completed with several names as potential arbitrator. If you still have the ARB1 that was completed by Gavin and Stacey, and I don't know whether I was the only person for a moment or two before I realised that Barry wasn't actually a third party. But if you look...
That's a bad business.
If you look at paragraph 3b, which must be on the third page of that, you will see that there are three possibilities. Over the page you get, it's at 4. 3a, we wish to nominate the following member. So you've gone through the process of identifying the particular individual person with all the potential difficulties. 3b, which is relatively new and is an amendment to the ARB 1, we wish IFLA to select one of the members of the panel from the agreed shortlist, so that what is created is effectively your ideal, your dream court, if you like. You will put down 3, 4, 5, 6 people who've given you quotations that are acceptable and whom you would trust. And the final determination of the arbitrator who will be instructed is thereafter entirely at random. IFLA will select at random the person who is to determine the case. And that, I suggest, is a sensible way forward. As to the amount, and here I am slightly concerned that I'm going beyond anything that perhaps I should, and as I say, these are personal remarks, though I've spoken to one or two about it. What is the fee likely to be? I think the best indication that I could give, from my experience both as arbitrator and also as an advocate appearing before an arbitrator, is that the fee that is likely to be charged by the arbitrator will be no more than, and probably slightly less than, perhaps by 20% or so, than that individual arbitrator would charge were he advocate in the same case. That's quite a long sentence, but I think you understand what I'm saying. So if you have in mind the particular person, if he was appearing as the advocate for either side in it, whatever his fee would be, and you'd have a broad view as to what that might be, it certainly wouldn't be more, and in my experience, somewhat less. Now, this is not to suggest that it's easier to be a judge than it is to be an advocate. I wouldn't dare suggest that, but if one is dealing with one particular case and nothing else, and is able to pre-read that, the actual amount of involvement put in, one can imagine, is less for the arbitrator than it is going to be for counsel, who's had to deal with his client, has to conduct the hearing, etc. So I don't know whether that is a helpful, I hope it's reasonably accurate, I think it is, indication as to how fees might be. But as I say, fixed fees are available. I don't know of anyone who refuses. There may well be, as I say, bolt-ons or escape routes. Well, I thought it was 1 day, it turned out to be 3, and they will have quoted for what those extra days might cost, and if other matters arise. But otherwise, I think it is quite possible for one to be in a position where one can advise one's lay client as to the likely additional cost of bringing in the arbitrator, and of course, against that, one has to set the fact that the case will be over so much quicker, as inevitably it will. Thank you very much.
Alex Vernon, QC, from Four Paper Buildings, is going to unveil the second unveiling of the evening.
The title of my presentation, short presentation, you'll be glad to hear, is Children Arbitration on the Horizon. And the horizon's much closer than we could have imagined a few years ago, when I was on a committee which was asked to look at arbitration in financial cases. I'm not an arbitrator, I'm not a financial practitioner, but I was on that committee. And although it was a few years ago, at that point we did not think the scheme could be extended to children cases. I don't know now why we thought that. We perhaps were overcautious. Perhaps we thought this needed to be done in stages. Perhaps we were over-worried about the idea of trying to circumvent the court's jurisdiction in relation to welfare cases. But the climate has changed in those few years. As you've already heard, arbitration has been endorsed by the courts, by the President in SNS, by Mr. Justice Baker in AI and MT. Dispute resolution is almost government-approved policy now. It's promoted in the family justice system. It's accepted in the profession. And lay clients are probably wanting it more and more. And so in February 2015, IFLA set up another subcommittee, which I was roped into, to look at extending the scheme to children cases. And the subcommittee was chaired by His Honour Judge Horowitz, Queen's Counsel, and got to work very quickly. And a final report was sent by the end of May, which recommended the extension to private law children. I stress private law as opposed to public law for reasons which are, I'm sure, obvious. It devised a framework for the scheme, it outlined the proposed training, and provided draft rules, which, as I understand it, are almost finalised. It looked at the following key points: the status of arbitration in children cases, the scope of such arbitration, training and qualifications, safeguarding and domestic violence, and children, wishes and feelings, the voice of the child. And let me touch on each of those briefly. We had a very constructive and healthy debate about the whole issue of the status of an arbitration, and we concluded that there was no legal obstacle to a system of binding arbitration in children cases, acknowledging, as we had to, that despite that, it would be open to either of the parties to go to a court and argue for a new determination, presumably on the basis of a change in circumstances. We were obviously fortified by the decision in SNS. We took the view that in a children law case, the court was likely to approve the decision, and unless something leapt off the award to suggest that something had gone seriously wrong. We were fortified by Mr. Justice Baker's decision in AI and MT, and took the view that the court was likely to give considerable weight to the arbitration decision without precluding either party's right to apply to the court in the future. The whole mood we are currently working in is pro-arbitration, and we could see no reason why there should be any distinction for children cases, although we ultimately had to accept the public policy that the court's protective function in relation to children could never be excluded, even by agreement. So then we turned to the very difficult issue of scope. It took us moments to realise that it couldn't touch public law cases or adoption cases. But then we started looking at what sort of private law cases really arbitration could apply to. And we came to the very firm view that it could not apply to Hague Convention proceedings, international proceedings, either pursuant to the Hague Convention or the court's inherent jurisdiction for summary return of children. It could not apply to serious medical treatment cases. It could not apply to cases where a party lacked capacity, and it could not apply to cases where a child ought to or should be a party. But, and this caused us some debate and took some time, we did think it could apply to relocation cases to Hague Convention countries, and certainly did think it could apply to what we call internal relocation cases, people moving from Dover to Newcastle. But in those cases, we thought the award would have to be subject to a condition that the parties agreed to lodge an order to reflect the award. As for training and qualifications of arbitrators, the view of the committee was that anyone who wished to be an arbitrator in a children case needed to show experience of children law, either by being a judge or holding some type of judicial office, or by having 10 years' experience as a practitioner, and requiring, in either case, 2 referees. The training that's been devised is a 1-day top-up training course for existing arbitrators and a 2-day course for people who are not arbitrators.
and will include, in particular, a session on the voice of the child and safeguarding, which again was something which caused us a degree of consternation. And let me tell you with the solution that we've come up with. We've certainly rejected the idea that there should be an entry requirement for all parties to produce evidence that they've had no contact with the police or no contact with the local authority. We thought that was cumbersome. It really worked against the whole scheme of arbitration. It would lead to delay. We toyed with the idea of trying to involve CAFCAS in the scheme and trying to get CAFCAS to do the preliminary safeguarding screening as they would do in private law disputes in court. But we took the view that CAFCAS don't have the time or the resources to be able to extend that level of help. And so we've adopted the system used in mediation, which is that the parties are told that checks are not available, and the arbitrator is allowed to ask for pre-checks in certain cases where on the face of the papers there seems to be a problem. And the arbitrator can, in a particular case, say that pre-checks from either the local authority or the police are a precondition to arbitration are continuing. So in those situations there would then be really a duty on the parties to raise that issue. We also acknowledge there's a duty on the arbitrator to refer concerns to local authorities in certain serious safeguarding cases. The last issue which we looked at and again thought about very carefully was the voice of the child and how best to reflect that. Certainly CAFCAS wouldn't be involved in children arbitrations, and so the view taken was that independent social workers should be used in complicated cases. Normally, in the run-of-the-mill case, the view taken was that we could rely on what the parents said about what the children's wishes and feelings were. But in certain cases where the wishes and feelings of the children were pivotal, an independent social worker could be used. And that is going to be reflected in the rules. We considered the whole issue of seeing the child, and at the moment took the view that that was probably not appropriate. It raises lots of issues in relation to checks and safeguarding, apart from the practicalities of involving a child. Although the subcommittee was open to the idea of involving children at some further stage in the process later on. And as I've already said, we took the view that arbitration was not appropriate for cases where children should be parties. I can tell you that the new scheme will be launched in spring 2016. The rules are almost ready, I'm told. The training materials are being produced. And as I've said, the aim is to run a weekend conversion course for existing arbitrators in late February and a full course for non-qualified but eligible people in April. So the horizon is nearer than we thought. Thank you very much.
So can I ask whether there is anyone who'd like to pose a question anywhere across the range to any of our speakers?
What is the rate of take-up?
76 is I think, a depressingly small number. It's true to say that it's grown exponentially. I think it was 50 not that very long ago, so it's moved on. But bearing in mind the scheme started, it was kicked off in March 2012. That is a depressingly small number. It is, however, possible that it's a false number, because although there is an obligation within the rules for an arbitrator to ensure that a copy of the Form ARB1 is lodged with IFLA, there's no fee involved, there's no supervision involved, there's actually no obligation, there's nothing to stop you conducting an arbitration under IFLA rules without notifying IFLA, except that it would be very unhelpful from a statistical point of view and might possibly lead you into difficulties if any disciplinary issue arose. But 76 is the current quota, or at least it was last week.
That's about ARBS1, not necessarily of awards.
That's ARBS1 lodged.
Yeah.
Arbitrations commenced. Yeah. And of course, quite a lot of them settle along the way. Some, I suppose, terminate without reaching either a settlement or an award, although I've not heard of any that have broken down. And the other key statistic, I suppose, is that there are 162 arbitrators on the panel. They're people who will have undertaken a 2-day training course, who will have passed the test of writing an award on a series of facts with which they're presented, and who will then have taken up their membership, thus entitling themselves to practice as an MCIR, a member of the Chartered Institute, and to have their name on the panel, which is published on the ifla.org website. I hope that answers your question.
It does. Are there other jurisdictions that have a developed family arbitration system?
Scotland started a year ahead of us. Their system is called FLAG. I can't quite remember what the acronym stands for.
Family Law Arbitration Group.
Family Law Arbitration Group. Thank you, Nigel. And we have had quite a lot of discussion between ourselves, in particular with Rachel Kelsey, who's a very active member of that group. The big differentiation with Scotland is that they started from the off, dealing with both children and money. But of course their legal system is quite different, and I'm told that, Rachel tells me that when an arbitrator makes an award, it is really only in the rarest of circumstances that they need go anywhere near a court with it. They just carry on.
Can I mention as well that there's an academic in Cardiff University called Wendy Kennett who's taken an interest historically in family law matters and also in arbitration matters, and was interested in family arbitration before IFLA came into existence. I've seen a draft of quite a long article that she's written looking at comparative jurisdictions throughout the world dealing with arbitration. It's taking forever to get published. I think it's all being peer reviewed and approved now, and hopefully will get published in the not too distant future. I saw it about 18 months, 2 years ago. As I recall, but don't hold me to it, that she had something to say about Israel and Germany, but hopefully shortly be published, and one will see a picture. I do recall her talking about the privatisation of private family disputes throughout the world, and it was a trend that was being seen across the piece.
Scotland's the most obvious example. British Columbia has a developed system. Australia have a developed system, but I'm told by those in the know that the take-up is very, very modest. Hong Kong, interestingly, produced a variant on it about 6 months ago. The judges there were so persuaded by the idea of arbitration that they've produced, as it were, a practice direction. It's a pilot scheme only. It sets out forms that people have to sign. Interestingly, they have to disclose what the fees are, and it provides for a whole system through from court approval at the beginning of the arbitration through to registration of the order at the end. But I'm told that the uptake has been zero. I think that's possibly to do with the sort of demarcation dispute between the arbitrators who tried to set this up, not having been too consultative in relation to the lawyers they hope would be their clients. So it may be that there are external factors there that are affecting it. But, of course, arbitration as a process is worldwide and universal.
Oh, yes.
Yeah.
But, I mean, you're trying to establish the merit of ad hoc arbitrations, as I said.
Yes.
Which, I mean, I'm just wondering if there is any jurisdiction that you're aware of where family ad hoc arbitrations is the majority process.
No. But one of the answers to your questions were who are the target audience? You say if they can agree sufficiently to agree to arbitration, why are they going there at all? The answer to that, I think, in a sentence, is because they or their advisors, quite often just their advisors, can also agree about another thing, which is that they're never going to agree. If you follow me. Never going to agree on an outcome. Going to need a decision. So they've got to agree, first of all, it's got to be obvious that they're going to need someone who's going to take a decision. And the choice then becomes arbitrator or court. It doesn't stop them reaching an agreement on the way. But if it's one of those cases that looks from the outset as though it's going to end up in court, then from the outset, we would suggest, arbitrators would suggest, that the professional advisors should be thinking about arbitration as an option to court. Nigel.
Just one other point.
Nigel, loudly.
Sorry?
You didn't have to say that for me.
One other point is that it's interesting mediators considerably as a mediation impasse breaker.
Yeah.
And a lot of the mediators are saying that there's lots of mediations which come to the point where almost everything is agreed. It's just there's one thing that's holding them back. For example, they agree that it's a term order, they just can't agree whether it's 5 years or 7 years. That can be put out to arbitration quickly on paper, outcome comes back, mediation can then conclude with that particular issue freed up, if you like. And that's creating quite a lot of interest amongst mediators.
There are some who think the same might be true of a collaborative process that reaches an impasse. However, resolution, and Nigel, I expect you resolutely to maintain the resolution position. I don't agree with that, although I think they are prepared to think about it.
Shall I explain?
What it is? What are you talking about?
Collaborative process, where the parties have agreed with their solicitors that they will never go to court, and if they do go to court, end collaborative and end of instruction of those lawyers. Arbitrators, I think many of them think, that if they get in their collaborative process to a point where there is an impasse, a block, they might go off to an independent expert for an opinion, which binds nobody, which might actually not resolve the block. Or they might, it is suggested, each write instructions to an arbitrator to resolve the impasse.
What do you say?
It's an ongoing debate. The debate is between what we might call the purists and those that believe that a process should be perhaps more client-driven, and we worry too much about lawyers and what clients want is an outcome. So it's the same argument with med-arb, where the mediator changes hats if the mediation doesn't succeed and becomes an arbitrator. So it's about the nature of collaborative requiring an openness and honesty within the process, where you learn more perhaps about how people tick in that process. That means that to become an advocate for their cause subsequently puts you in a difficult position. But it's an ongoing debate, and there are plenty within the resolution ranks that feel that we are being too precious about it.
That's interesting. I've got another question. What happens if an arbitration goes off the rails halfway through? You discover that one party is being thoroughly dishonest, you need a freezer, and you want to abort the whole thing?
Well, you can go off to court within the process, can't you, under the Arbitration Act for peremptory orders, and bring it back again. And if
it's a freezing
injunction,
then the arbitrator has no power to grant interim injunctions.
No.
And therefore it would be necessary to commence proceedings if there weren't any proceedings, or to apply for permission. Imagine permission can be given, even where there's been a stay. The arbitrator could say, I authorise you to go to court about that. It might or might not then be an arbitration claim, but if it's an injunction application, like a freezer, then I would imagine they go straight to court and not mess about.
But if you went to court for a freezer, would that abort the arbitration and mean that it would start as a financial remedy de novo in that court?
Not necessarily. And while we're on that point...
Not or yes? No.
No.
The arbitration would have to terminate the arbitration. There's a provision in the Act for the arbitrator to do that.
Certainly the arbitrator can terminate.
No, the parties unilaterally can't pull out.
No.
They have to agree to terminate.
Either they have to agree to terminate, or the arbitrator can decide that he is unable for whatever reason to continue. And just on one other tiny point, Nick, that you mentioned, if it ever got to the point in a financial arbitration where the judge before whom the award is taken because it needs to be made into an order, because, for instance, there's a clean break provision, or there's a pension sharing provision which you have to have an order about, and if the judge, at whatever tier, said, I'm terribly sorry, but I simply cannot bring myself to approve this order, I do not believe it is a sensible order for whatever reason, it's outside what I would do under Section 25. And it seems to me that it isn't a question necessarily of, it isn't an appeal, it's just refusing to make an order. And the parties would then have the option of either going back to the arbitrator or of negotiating. It wouldn't necessarily be the case that they had to start proceedings.
Okay, that's interesting. In California, because the court system is on its knees, almost everybody who's got any money at all hires a private judge.
Yeah.
And the private judge does the FDR as well as the final hearing. Why could an arbitrator not do that, do the FDR as well as the final hearing?
Because there's a provision in about Rule 14 that says if you're an arbitrator, that is the only function you perform. So you can't mediate and then become the arbitrator.
Okay.
I imagine you could do it outside the scheme rules, but this is still grey area stuff. If you're going to go by...
Paul Coleridge has argued for a long time that the FDR judge should be able to be the trial judge. He said, you know, we're not bound, we're not particularly influenced by what people ask for. I would suggest that people should have the option to have a private judge to do all aspects of their case.
I think that raises wide issues, which we could perhaps discuss, but not in this forum.
Okay.
It's very interesting. I think that the basic principle is the perception, the individual's perception of fairness, and how can a judge who's been told what your best offer is and what the other side's best offer is, surely that's bound to affect their judgment as to what the right answer is. But I mean, I'm sure there are arguments both ways. I didn't know that was one of Paul Coleridge's hobby horses.
Surely the answer to this is that what was thought inconceivable 10 years ago is now thought entirely conceivable and desirable. This is an ongoing process.
And it's got
who knows where it will go in 5 years' time?
And it is, I'm afraid, being pushed. The boundaries are being pushed partly because of difficulties within our court system at every level of every sort.
FLBA have been very keen on arbitration for a long time, and I think those who arbitrate know this to be true. We perceive this to be a very, very important future source of work, both for arbitrators but also for advocates. Arbitration is litigation proper, and that's the thing that we need to be selling. It is going to court, although it looks a bit different, and having your battle. And there are lots of people who want to have their battle. This is a method of putting agreed confines on it, and the default position is the same as the court position, but you can compress the timetable. Now, what we haven't done and what we propose to do is a lot more in terms of information to those people who are looking at persuading solicitors and their lay clients that arbitration is a good thing. It is interesting to note that most arbitrations involve people who are arbitrators or who have been in arbitration beforehand. And so everyone who's been through an arbitration is very, very proud. And the only issue really is getting people into arbitration itself. In terms of the hearing, the environment, the experience generally, and as an advocate, the ability to conduct your case in a way you can plan beforehand is a massive advantage, and we should be trying very, very hard to sell this.
It's word of mouth, and so if you've got colleagues in chambers or in your firm who you know have been engaged in arbitration, perhaps as an advocate, I'm sure you can ask them what they thought of the process and how their clients reacted to it without them disclosing anything that it would be inappropriate for you to know about the actual detail of the case.